Hi, this is Jen Rubin, editor-in-chief of the Contrarian. Back with us to explain all things Boasberg, all things habeas corpus, is the wonderful Steve Vladeck, who is a magnificent constitutional and Supreme Court scholar. Welcome back, Steve.
Thanks, Jen. Such a pleasure to be back with you. Although we got to stop meeting under these circumstances.
I know, like, why don't we have a good news day, right? We'll have one of those once in a while.
I mean, the Mets are 8-3. Okay, so I'll take what I can.
Okay, well, the Dodgers are doing pretty well, although they haven't been doing that well in Washington, so I'll take that too. Uh, let's start with the aftermath of the habeas decision. As our readers, listeners know, yesterday, the Supremes kind of sent the plaintiffs back under a different legal theory and perhaps to different places. What happens now, both to the people who are confined in various places in the US and those people who are still in El Salvador?
Yeah, I think that's exactly the distinction we should draw. So let's start with the folks who have not yet been removed. Obviously, I think the most important positive thing that the Supreme Court held on Monday is that all of those individuals are entitled to notice and a meaningful opportunity to challenge their removal before it happens. And so, Jen, the question is going to be, where does that happen, not whether it will happen. We've already seen an effort by the ACLU to file a class action on behalf of anyone who might be subject to the Alien Enemy Act proclamation in Manhattan in the Southern District of New York. As you and I are sitting here, Judge Hellerstein has apparently granted a sort of a small temporary restraining order for some of the plaintiffs in that case, but not everybody. So that's actually in limbo, even as we are sitting here. I think probably what's going to happen is two different things, that there will be individual habeas petitions filed by some of these folks where they're detained. And so that can include in the Southern District of Texas or in other parts of the country, and that there's going to be an effort to get nationwide, class-wide relief that I think is going to be a bit of an uphill battle because of how much harder the Supreme Court has made it over the last 15 years to certify a nationwide class. So those are going to be the two fronts, right, on which we see cases by folks who are still here. For the folks who are in El Salvador, I think a lot is going to depend upon what the Supreme Court does with the federal government's pending emergency application in the Abrego Garcia case. So, as you know, Abrego Garcia is the guy who was wrongfully removed to El Salvador, not under the Alien Enemy Act, so he's in a bit of a different legal status. But it's the same, Jen, jurisdictional question about whether federal courts, by issuing process to federal officials like the Secretary of Homeland Security, can require the federal government to take whatever steps they can to bring these people back. And so, my suspicion is that as soon as the Supreme Court rules on that application, which, Jen, could easily be today, we'll see movement on behalf of the other, we don't even know how many, right, non-citizens who were removed to El Salvador under the Alien Enemy Act. Maybe a habeas petition filed in the DC Federal District Court, which is historically where extraterritorial detainees have been allowed to file. Maybe an effort to file somewhere else. But I suspect that's why we haven't seen that yet, is because the lawyers are waiting to see what the Supreme Court does with Mr. Abrego Garcia's case.
Couple questions. The Supreme Court made a big deal of the fact that you had to bring a habeas position. Habeas is basically send me the body, give me the body, in the place in which they were incarcerated. If you have a nationwide class action,
Right.
how does that work? Because you have people in different places.
Yeah, I mean, so I can tell you how it should work. How it will work is not up to me. So, in normal class litigation, right, we ask a couple of questions. We ask, is this district an appropriate venue? And we ask, does this court have jurisdiction over the defendants? And so, the venue question can be satisfied even if only some of the plaintiffs are in the district, right? That nationwide class actions wouldn't be possible otherwise.
Right.
There's no case law that I'm aware of, Jen, that answers the question of how you reconcile that with the district of confinement rule, which says you got to file where you're detained. I would think that the district of confinement rule, which is a judicial gloss on the federal habeas statute, ought to give way so long as at least one of the named plaintiffs is filing in the district of their confinement. But I also can't say with confidence that that's what this Supreme Court would say if put to the test. And just one other really quirky thing, because my civil procedure students will yell at me if I don't raise this. Class certification orders are actually one of those rare interlocutory rulings that are immediately appealable if the Court of Appeals wants them to be. And so we might find out the answer to this question actually very quickly.
Now, the other issue here is that in the separate case that is in Maryland, the Garcia case, the government made a mistake, and they seem to have acknowledged that they've made a mistake. He shouldn't be there. And their position has been something along the lines like, we can't get him back. Is that going to fly? And will the Supreme Court, and then in turn, whatever lower court takes this up, say, well, we may not have jurisdiction over the government of El Salvador, but we have jurisdiction over you, Mr. Justice Department Attorney, and you go and try your best to get him back. How is that going to play out?
So again, I should say, I don't know. By the time folks are watching or listening to this, the Supreme Court may have answered this question. I mean, I would expect that we're going to hear from the Supreme Court, if not today, Wednesday, certainly by the end of this week. I will say all of the precedent is on Mr. Abrego Garcia's side. I mean, whatever the White House might want to say, whatever Justice Department lawyers might want to say, we have at least 60 years of Supreme Court and lower court cases holding that the question is not necessary. Federal courts have power even if you're not in the actual physical custody of the federal government, so long as something a judge could order the federal government to do could provide you with the relief you're seeking. And my favorite example of this is a case from 2004 involving a U.S. citizen named Omar Ahmed Abu Ali, who was being held in Saudi Arabia by the Mahabith, the Saudi intelligence services. And his parents brought a habeas petition in D.C. saying that the Saudis were only holding this guy because we were telling them to. And so Judge Bates, who is, very, sort of by the book, law and order, Republican appointed district judge, said, listen, at least based on the allegations in the petition, I have the power to do something. I can tell the U.S. to stop telling the Saudis to hold this guy. And so Bates ordered what we call limited jurisdictional discovery. Basically, he wanted to have a hearing so that the allegations could be tested, so that the U.S. could be forced to testify about what they were doing. And magically overnight, the U.S. put Abu Ali on a plane, brought him to Virginia, and indicted him in criminal court, kind of proving the theory of the habeas petition. But Jen, the assertion of jurisdiction in that case over a guy who was in a Saudi prison was not out of the ordinary. It was not controversial. It was entirely in line with all these precedents. And so, if the Supreme Court is going to follow those precedents, it ought to follow that Judge Sheenis in Greenbelt can order the Secretary of Homeland Security to take whatever steps are available to her to get Mr. Abrego Garcia back. Jen, the hard question is, right, what if the secretary turns around and says, oh, I've tried my hardest, I've done everything I can, and I just, we can't do it. That's, I think, the messier question, but that's less about the federal court's power than it is about the Secretary of Homeland Security's candor.
Right. Now, when they have a habeas hearing, what gets to be argued? Do they get to argue, for example, this is incredibly illegal because the statute on its face requires we actually be at war and that a nation be invading us, and this gang doesn't count? Do they get to litigate that? Do they get to litigate whether the guy or gal, I think they're all guys, are a member of the gang? What gets argued?
So again, just going off of the precedent here, right? I mean, the Supreme Court in 2008 in the Guantanamo habeas case Boumediene was pretty clear that habeas means a right to test any factual or legal basis for your detention. And so in the case of alleged alien enemies, Jen, I think there would be at least two and maybe even three sets of questions. So the sort of meta question, right? Is the invocation of the Alien Enemy Act valid on its face? I think that's fair game because if the answer is no, then you have proven that you are not lawfully detained. And that's the gravamen of the habeas petition. So we might call that the facial question, right? Then there's the as applied question of whether individual person, whether Steve Vladeck is a member of Tren de Aragua and is therefore covered, Jen, not just by the statute, but by the president's own proclamation.
Right.
Right, which limited the scope not to all Venezuelans, but to Venezuelans who are not green card holders and who are members of Tren de Aragua. And so it seems to me that you could also object to both of those questions, right, in a habeas petition. And then the half one that I put below that is even if the government claims you're a member of Tren de Aragua, right, I think you can object to the sort of quantum of evidence that the government has to bring forth. In the Guantanamo habeas cases, the DC Circuit eventually settled on preponderance of evidence as the relevant standard, meaning the government has to show that it's more likely than not that you are, or in those cases, a member of Al-Qaeda. I actually think there's an argument for an even higher threshold here, because unlike the Guantanamo detainees, these folks were in the United States at the time they were arrested. They clearly have due process rights. And so I think actually probably the right standard is clear and convincing evidence, which, if you wanted to try to quantify it, like more than 3/4 of the evidence, it's not as strong as beyond reasonable doubt, but it has to be more than just 51%. I think that's probably where this ends up.
Now, it does seem that it's not only that the government may not have clear and convincing evidence, it may not have really any evidence at all. What we found out in the Greenbelt case was that the basic of, a couple of allegations, a tattoo that doesn't really apply, the basis on which these people were sent is so paper thin. It somewhat shocks the conscience, to borrow a phrase. Has the government proceeded in a fashion like this with such little evidence about even on its own face, the basis for deporting these people?
No. The only example that comes to mind is the Yasser Hamdi case, again, going back to the war on terrorism context. So Yasser Hamdi was a U.S. citizen who was picked up by the Northern Alliance in Afghanistan in the fall of 2001. We should say at a time when we were paying bounties to the Northern Alliance for every single person who they turned over to us. And, the government's basic assertion against Hamdi is that he was a member of the Taliban and that he was fighting with the Taliban against the U.S., in and around Tora Bora and elsewhere. The government fought desperately in the federal courts for the better part of 2 years to not have to produce anything more than a declaration, basically an assigned affidavit by a Defense Department bureaucrat, a guy named Michael Mobbs. And the government's argument in the district court in Virginia in Hamdi's habeas petition and in the Fourth Circuit, and even in the Supreme Court, was that it had to show some evidence that Hamdi was who they said he was, but that the declaration by itself was enough. And it's striking, Jen, that it took the federal courts 3 years to say no, but they said no. I mean, so in the Supreme Court's 2004 decision in Hamdi versus Rumsfeld, although the court fractured about everything else, the one unequivocal majority holding was that Hamdi was entitled to much more process before he could be, to continue to justify his detention. And so on remand, I think, folks know Hamdi, folks may not know what happened on remand. On remand, right about the time when it was the government's burden to produce the evidence, the government made a deal with Hamdi and basically signed a release agreement where they agreed to let him return to Saudi Arabia, where he'd been living, if he promised to relinquish his citizenship and never do it again. So, that case is not exactly, I think, a compelling precedent for the notion that we should just trust the government in this context.
Right. And that is kind of what is striking overall, is on what spurious pretext this can happen. As we reach the end of our time, I want to zero in on something that Justice Sotomayor said. She was one of the signed dissents in the per curiam decision. By the way, I never remember a per curiam decision, per curiam meaning no one identifies themselves, with so many named dissents, by the way. So I think we know who was part of that per curiam opinion. She essentially said there are 9 justices here who have already agreed, or sort of maybe a little bit of dicta, but they have agreed that you get some kind of due process. You cannot simply scoop these people off and send them off. So if you, Mr. Government, do this again, you will be in violation of what the Supreme Court has said. Question whether that's right, whether that's technically accurate or not. Interestingly enough, the most interesting justice that you and I have discussed, Justice Amy Coney Barrett, agreed with that part. Does that really hold weight? In other words, is the government going to continue to do this and test that kind of concept, or are they really at this point stopping from sending any more people without a full hearing?
This is a great question, Jen, and I'm sorry to be a broken record, but I think it will depend. So, I think it is possible that we look back a couple of weeks, a month from now, on Monday's ruling by the Supreme Court as actually much more of a loss for the Trump administration than we thought, because maybe federal courts, wherever these cases are brought, Texas, New York, wherever, really do put the government to its paces. And, even if it's a moderate standard, Jen, even if it's a standard that's lower than I would want it to be, as you note, that still might not, the government may not be able to clear even those lower bars.
Right.
If that happens, then I think we'll look back on Monday's ruling as actually a pretty big win for the future ability of President Trump to rely upon the Alien Enemy Act for mass, sort of non-individualized, suspicionless removals, because that will stop it. And if the government really has to go through its paces in every individual case, I think the government will be disincentivized from using this authority as opposed to the ordinary authorities in the immigration system.
Right.
That doesn't do anything for the however many folks have already been removed under the statute.
Right.
And it is going to depend upon those lower court rulings being upheld by the federal appeals courts that review them. And, it's not a coincidence that the government is fighting so hard to get these cases into Texas, because that means it's the Fifth Circuit. And so, I think it is very possible that even the Fifth Circuit, about which I've said quite a lot, which is, easily the court in which the government's most likely to find favorable arguments in these cases. If even the Fifth Circuit is enforcing the meaningful, individualized notice and review mandate that the
Right.
Supreme Court handed down on Monday, then I think going forward, right, these cases are not going to terrify us.
Right.
But I still worry about the backwards looking cases, because there are still,
Yes.
somewhere north of 140 people who were removed under the statute who are in the CCOT in El Salvador. And as in the Abrego Garcia case, I worry about setting a precedent where even if that was in error, whether maliciously or negligently, the courts are somehow powerless to correct it. Like, that's a big problem to me, even if the future cases come out better. And that's again why I think the pending Abrego Garcia case is such an important second act, right, to
Yes.
figuring out what to make of the Alien Enemy Act ruling.
Yeah. And one final question. Where do these people go if they are released for any kind of remedy? Is there any
Yeah.
kind of damages? Is there anything that they can do to compensate for this horrendous abrogation of their rights and any physical damage that might be done to them when they're in El Salvador?
The answer ought to be yes. The answer is no. There's nowhere to go. And that's for two reasons. So the first is the Federal Tort Claims Act, which is the waiver of sovereign immunity that Congress has enacted when the government commits, even intentional torts, doesn't apply to torts outside the United States. And so any bad things that have happened to these folks in El Salvador are outside the scope of the Federal Tort Claims Act. And, you would think, and I've argued for years that it ought to be, that when the federal government violates your constitutional rights, especially when it does so maliciously and knowingly, you ought to be entitled to damages. The Supreme Court has narrowed the availability of those damages drastically, including a case I argued and lost in 2019 called Hernandez versus Mesa, where the court refused to allow the parents of a 15-year-old Mexican national who was killed in an unprovoked shooting by a border agent while the agent was standing in Texas and while the kid was standing in Mexico. The parents weren't allowed to recover damages. If they couldn't recover damages, no one's going to be able to in these cases. And that's a real problem. And, if we get to a point, Jen, where we're able to start talking about how to reform the system in light of what we've seen, one of the things that I think is being driven home by events of the last 79 days is that the law is set up pretty well to stop ongoing illegality by the government. There are huge gaps when it comes to punishing completed misconduct, which is a problem not just for the victims, but it's a problem for the lack of deterrence that creates for government officers. If the worst thing that happens to you for doing something unlawful is you have to stop doing the unlawful thing, that's not a deterrent. And I think, we should want deterrence no matter how much we like or dislike whoever's wielding the power that we're trying to deter.
Well, Steve, it's always fascinating to talk to you. And if bad things ever stop happening, and I fear that they won't, there will be a fascinating discussion about all the things we have discovered within the system that really need greater protection, loopholes closed, faster remedies for people who are harmed. Because until now, we've essentially dealt with administrations, by and large, with some exceptions, that have operated in good faith. And when they don't, and we see these horrendous miscarriages of justice, I think we then have to go back and say, all right, what do we do going forward? But that is a discussion for another day. As you say, the first task is to keep them from doing bad things. So we will rely on you to keep explaining them to us as long as bad things are happening, which unfortunately may be for a while. So thank you for joining us. It's always a pleasure.
Thanks, Jen. Always great to chat with you.